Judge rules government can't sub for Trump in E. Jean Carroll's defamation case. A week before the election, Donald Trump is still working on evading lawsuits, except he was trying to pass it off on the Justice Department to do his work. The judge was having none of it and rejected the DOJ's bid to make the government the defendant in a defamation lawsuit. Journalist E. Jean Carroll accused Trump of raping her in a Manhattan department store in the 1990s. Trump denied that he had done this in an interview last year. Carroll filed a defamation lawsuit against Trump in New York last November. Last month the DOJ moved the case to federal court and asked for the U.S. government to be substituted as the defendant in the suit, as Trump is an employee of the government. The DOJ further argued that Trump was acting within the scope of his office as President of the United States when he denied that he'd met up with Carroll in a dressing room and raped her. This was seen as a way for Trump to get out of the case. By making the government the defendant, attorneys could invoke the notion of sovereign immunity. Lawsuits are not allowed against the government, so it would lead to a quick end. U.S. District Judge Louis A. Kaplan ruled that Trump didn't qualify as an employee of the government under federal law and that he was not acting within the scope of his employment when he denied he'd raped Carroll. The President of the United States is not an employee of the government within the meaning of the relevant statutes, wrote Kaplan. Even if he were such an employee, President Trump's allegedly defamatory statements concerning Ms. Carroll would not have been within the scope of his employment. Trump had initially sought to delay the case, but that was denied by a New York judge. Carroll's legal team was seeking a DNA sample from him to compare to the biological material on the dress the journalist was wearing the day of the assault. A discovery interview was being sought from Trump as well. Roberta Kaplan, an attorney for Carroll, said in a statement she was very pleased that the federal court interpreted the plain text of Federal Tort Claims Act as not covering President Trump's false statements about our client. The simple truth is that President Trump defamed our client because she was brave enough to reveal that he had sexually assaulted her, and that brutal, personal attack cannot be attributed to the office of the president, she added, while also noting that the rest of the legal team looked forward to proceeding with the case in federal court. When I spoke out about what Donald Trump did to me in a department store dressing room, I was speaking out against an individual, said Carroll in a statement. When Donald Trump called me a liar and denied that he had ever met me, he was not speaking on behalf of the United States. I am happy that Judge Kaplan recognized these basic truths. It is commonplace for the DOJ to intervene in lawsuits against federal employees, but critics believe Trump was using federal resources to protect himself in a personal matter. Attorney General William Barr defended the actions of the DOJ to defend Trump, noting that legal precedent was on the government's side and that any negative talk of the DOJ's move was because of the country's bizarre political environment. He added that the White House had asked the DOJ to intervene and litigation experts agreed.